Grossman, good to see you. Until they actually get started.
All right, I'll just park back here then.
I assume they're gonna be going in order of the docket for the bankruptcy case first.
I believe so.
Well, if
Well,
not,
bankruptcy case now,
Oh, it's not?
I'm sorry,
he's gone to the bankruptcy case.
I've got,
He just said the bankruptcy case.
Oh, I thought it was a bankruptcy case.
It involves bankruptcy.
Oh, okay.
it's,
That sounds like an issue I don't necessarily want to get into, so.
me neither, but we're here.
judge presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to the 5th District Court of Appeal oral argument session this morning. Let me start by introducing the judges on our panel. I am Judge Boatwright. To my right is Judge Adrian Soud, and to my left is Judge Paige Kilbane. We have 2 cases on the docket this morning. Each side will have 20 minutes to argue their case. The appellant is allowed time for rebuttal arguments, so when you come forward, please let us know how much time you would like for rebuttal. So the first case we have on the docket is 23-2222 Choice Towing versus TA Collections. You ready, sir? Good call.
May it please the court. Excuse me. Bill Gressley from Jacksonville on behalf of the appellant, who I call TTS.
How much time would you like for rebuttal?
I'm sorry,
Would you
5
like any
minutes
rebuttal?
is my
Okay.
aspirational goal. It never seems to work out that way, but we'll try. It's difficult to know where to start. This is actually a very simple legal question, but there's so many tentacles with bankruptcy thrown in, and the appellee has raised a number of issues which I submit are fundamentally irrelevant to the actual issue. The actual ultimate issue here is that the appellee had an opportunity in the bankruptcy court, who had exclusive jurisdiction over all these transfers that the circuit court judge below found allowed them to assert this state law claim for mere continuance based on the 4th DCA case of Dr. I can't pronounce his last name, but it's discussed at length in the brief. And in the brief, we're on day 1.
You're not disputing that GT lawfully obtained a judgment against TTR originally. What you're disputing is that once the new company was formed, GT didn't have any rights to levy on anything in the new company, correct?
That's correct.
Okay.
And the reason why this is not a mere continuation claim, this went through a bankruptcy court. This is what bankruptcy courts do. The trustee in bankruptcy here asserted that the transfers to my client, in order to be not considered fraudulent as to creditors, they negotiated a deal whereby my clients assumed a whole lot of unsecured debt, additional debt that...
Was the fraudulent transfer mentioned in the actual settlement agreement? I know it was mentioned in the notice, but was it mentioned in the actual settlement agreement?
The settlement agreement specifies that, well, this all arose from the trustee's claim that this was a fraudulent transfer, and then they negotiated and reached an agreement that they had resolved that issue. And it was at that point, GT, the appellee's predecessor, had every opportunity to object to this. I mean, their theory is that once they've admitted that the trustee actually is the one who sold the assets to my client, it was not a transfer. My client could not, the TTR, the bankrupt entity, could not transfer the tow trucks to TTS because they were liened. And they went through the bankruptcy process precisely to avoid having to have these kind of issues in multiple forums or in subsequent forums. This is what bankruptcy courts do. They have, the trustee becomes the owner of all the causes of action and all the assets, and the creditors can make whatever claims they feel are warranted. The dispositive issue here is that GT, TA's predecessor, had every right to object to this compromise of the fraudulent transfer claim. And it's not...
Let's assume you're correct that that was taken care of in the bankruptcy case.
But they didn't...
So now you have this mere continuation claim. Are they the same thing?
They're both species of a fraud on creditors. It was a claim, and we've cited on page 11...
Do they derive out of the same statutory authority?
No, the process is the impleading of a fraudulent conveyance claim against a third party. And that can take the form of a fraudulent conveyance where you, and that doesn't have to be to an insider or a related entity. You could sell your assets when you're insolvent to somebody else and get cash, and creditors can object to that on the grounds that you can't transfer assets when you're insolvent. The bankruptcy judge the circuit judge here made a number of misstatements about what actually had occurred here. One was that the TTR was insolvent when that selling the trucks to my client and the other assets rendered TTR insolvent. That's not correct. They were insolvent already. They were heavily indebted and underwater on all of the financing that they had. And that's why the compromise of all the trucks and the other assets that were part of the settlement agreement approved by the bankruptcy court gave GT every opportunity to say, we object to this because all you're doing is allowing a new business to take over where it's the same people running the same business. Well, legally it is not the same business. We did not take the title to any of the assets of TTR except through the bankruptcy trustee. And that's how the process works. That's why we have a bankruptcy system where claims of creditors can be sorted out. Bankruptcy trustee owns the causes of action, and GT sat silent.
Were they required to act at that point?
It's our opinion, absolutely yes. And the reason is in Justice Oaks' case, it talks at length. In that case, you shepherdized that case, and it's been cited dozens and dozens of times for what constitutes claim preclusion. GT had this claim, this mere continuation claim, arose out of the same operative facts as the fraudulent conveyance claim. And everything about this is subject to the claim preclusion analysis, which has all been met here. GT had every reason in the world to raise this issue. What they're ultimately saying is, well, TTS, my client, could buy these trucks and other assets, but they couldn't use them, or else we get to claim they're the same company. Well, that's legally nonsensical. And I direct the court to the Estate of Townsend case cited on 11 and 12 of my reply brief. That talks about the fact that you don't allow state court litigation, in that case it was probate litigation, to continue when the bankruptcy court already has jurisdiction. They have exclusive jurisdiction over these kinds of claims. And our ultimate position here is that GT had every obligation to either bring an adversarial proceeding or object to the compromise and claim. The answer brief claims that the settlement agreement was limited. There is no language of limitation whatsoever. There is no way you can read the Justice Oaks case as clarified by the Martin case and justify what the circuit judge did here. These are errors of law. The Martin case, which the appellee claims is an exception to the general rule, only explained that the statement in Justice Oaks that said that you can't enforce a settlement agreement, a bankruptcy court enters, you can't enforce that. That's taken out of context, as Martin pointed out. The state law equivalent of this is the Oliver v. Stone. I love the name of that case. Oliver v. Stone says that interim orders are all merged into the final judgment, and if you have an error that you want to bring on appeal of one of these interim orders, you have to wait until there's a final judgment. That's what the Justice Oaks case was. There was an interim order trying to approve a settlement that was challenged, and at the same time it was the confirmation plan, which was the ultimate final order in that case, was challenged. And the 11th Circuit said, that's why the Justice Oaks case is not correct on that point. You can, a final order, a bankruptcy court's order settling an issue is a final order, and that's what the Martin case says, and it's appealable. And so the idea that somehow settlement agreements and orders approving them in bankruptcy courts are not final and enforceable, which is the appellee's claim, is legally not correct. And you cannot read those two cases and fail to see that, legitimately.
Were there any findings in the settlement agreement as to the fraudulent transfer issue?
That's why there was a settlement agreement, because the trustee asserted that there were fraudulent transfers, and they compromised that and got more money out of my client and got my client to take on more of the unsecured
I
debt.
understand that, but was there any actual discussion of it in the actual settlement agreement itself?
No, and there didn't have to be. It recited that the trustee had raised this issue. That's how it came about. There would have been nothing else to talk about if you had to say, well, we alleged it was a fraudulent transfer. Well, that's what the trustee's motion pointed out, that we alleged a fraudulent transfer, and we've negotiated, and this is what we're doing. And GT had every right in the world to say, we object to this, because all you're doing is using the bankruptcy court to allow new corporation to act as the old one. Well, that's what happens in bankruptcy courts. And your exclusive remedy is to tell the bankruptcy court why you think this is not correct or not fair or not legal, and it's telling and it's dispositive that GT did not do that. They sat quiet until they saw that there was some equity in the real estate that once upon a time was owed by their judgment debtor, TTR, and they said, oh, now we've got to come up with a brand new state law claim that we didn't raise in the bankruptcy. And
Did GT have any role in the settlement agreement?
they chose not to. They were noticed that the trustee was going to compromise the claim, and they set a hearing. And the standard language under the local bankruptcy rules that we cited in our briefs says, if you don't object, we assume you are okay with the relief we're asking the court for. And they sat silent. They sat silent forever until they decided that they wanted to have the stay lifted to allow them to go finish asserting their claims against TTR to the extent that it was an unsecured claim, because they couldn't assert a secured claim. And the bankruptcy court issued an order, we've cited it in the brief in the record, that says you can go get your unsecured claim. Well, what do? They turn around and got a judgment, recorded them, and acted as if it was real estate, liens on the real estate owned by TTR, which at that point TTR did not own anymore. And then claimed, well, this is just a mere continuation, so now we get to foreclose our judgment liens. Well, those are void. The bankruptcy court just ignored, the circuit court just ignored that. But more importantly, they had every reason and every right to be heard on their claim that, wait a minute, you can't use bankruptcy like this. And I submit the reason they didn't do it is because that's legally not correct. That's what bankruptcies are for. And the fact that they were owed money by someone who couldn't pay it, if this wasn't a bankruptcy case, then we'd have all kinds of different legal options available. But this whole thing was dealt with in the bankruptcy court, and GT sat silent, and it's our position that they were stuck with that. They had to accept that they still have the debt owed to them by TTR, and that my client is not a mere continuation. It's a new business which had purchased its assets from the bankruptcy court.
And your position is it solely based on claim preclusion?
Yes. Legally, that's the ultimate answer here, is even forgetting all of the other things, which is this is not a mere continuation. This is a new entity.
And it's not a mere continuation because they purchase assets from the trustee, because otherwise,
yes, you
it's
could
clearly
make
the same
claim,
business,
but
it seems.
they're not identical. They lost 60% of their business by filing bankruptcy, and they lost at least one employee. I can't remember. There were some differences, but yes, you had all these similarities, and this has been transparent. That's what happened when you file bankruptcy.
Right, but you don't, for claim preclusion is a very specific doctrine, right?
That's correct. Yes, ma'am.
So,
same operative facts.
okay, well, that's not the only factor, though, right? There are other things to look at.
Sure, but the other
elements of
ones
the
are-
claims and all of that. And fraudulent transfer, you don't have to have a fraud necessarily to have a mere continuation, do you?
Well, why would it ever come up? It is a fraud on creditors. If all you're doing is putting a different name on the door and doing exactly the same thing, which is the doctor case from the 4th DCA, which we cited, they used everything. All they did was change the name on the door. Well, that's not what happened here. Yes, you have plenty of indications that, yes, it's the same business. My client's representative, Nicole Bostwick, said, we did this so I could continue in the towing business. But they did it through the bankruptcy court, and that's the dispositive point, is that the GT had every chance to raise this issue and have it adjudicated, and it could have it ultimately came down to a
Any
claim.
relevance to your argument that the trial court makes a point that this debt was not even discharged because it was a Chapter 7? Does that even have any relevance to the
It
argument?
has
you're
no
making?
relevance because Chapter 7 with a corporation is a liquidation. There are no discharges in that case, and that's black letter bankruptcy law. And so the confusion here is,
But they had filed a Chapter 7, correct? TTR had?
yes.
Okay.
Yes, it was a liquidation, and they have nothing left, which is why they've come up with this novel, entertaining and creative theory that lacks a legal basis. I'd like, if I could, for the first time maybe in my entire career, to save 6 minutes or 5:55 or whatever. Thank you.
Good morning, Your Honors. May it please the Court. I'm Eric Kohler, representing TA Collections, who's the assignee of the GT Leasing, who was involved prior with the appellant. I think the key legal concept here is there's a distinct claim between the mere continuation, de facto merger, alter ego, is a completely different claim than fraudulent transfer. And as you stated, what is going on here is that
Can that type of claim be settled in a bankruptcy proceeding?
No, it can't. And if you look at the Florida case of Seminole Boatyard versus Christoph, that case out of the 4th DCA specifically holds that a bankruptcy trustee does not have any standing to assert an alter ego claim. And in fact, no alter ego claim was asserted by the bankruptcy court. And if
Is a
you look,
fraudulent transfer claim and an alter ego claim one and the same?
no, and so
What's the major difference?
the major difference is there's no element of intent. There's no requirement of fraudulent intent for an alter ego claim. Furthermore, when you talk about an alter ego mere continuation claim, they're looking at
Are the remedies the same? Are the remedies the same? How you can
No.
seize assets? Are they different?
Right. So in a fraudulent transfer claim, the trustee, and if you look at the notice of intent, the trustee is saying, right before, what happened in this case is that on November 4th, right before a trial, the appellant got together with a couple of attorneys and transferred all their assets over to a new company, formed a new company. And then the next day, then they had TTR, the old company, file bankruptcy.
And that was on the eve of trial, correct? Or a couple
Well, it
of
was 3 weeks before the trial.
Okay.
So the trustee said, well, wait, all these assets were gone now from this company that filed bankruptcy. We want those assets back, okay? So they were saying, well, the assets weren't really worth anything. We'll settle. And also, the bank had a big lien on all the assets. So the appellant was saying at that point, well, the assets aren't worth anything. The bank has a lien. And so the trustee said, well, we'll give some money to the bank, we'll take some money, and we'll settle our claim against to get back these assets. A mere continuation alter ego claim says that the new company is liable for the old company's debts, okay? So that's a completely different remedy. Does that answer your question? Okay. So again, another difference is that when you look at an alter ego mere continuation claim, what they're looking at, and if you look at the Munum case, they're talking about the bottom line question is whether each entity has run its own race or whether there has been a relay-style passing of the baton from one to the other. And they look at, are the same services being provided with the same files, patients, employees, et cetera, okay? And then in this case, also, the alter ego claim is looking at what happened after the transfer of assets. So they look at what happened, what was the corporation doing, okay? And in this case, the judge says there was the same stockholder. It says there was the same level of income from 2009 to 2014. Of course, the bankruptcy happened in 2011. Both businesses were known as this fictitious name, Troy's Towing, T-R-O-Y-Z Towing. And Troy Bostic was the husband of the stockholder, okay? He was the guy who was going out on the towing runs. That name was put on the tow trucks both years afterwards and before. And then in 2002, Troy Bostic came into his deposition. He said, yeah, I've been working for the same company for 28 years. All we do is tow trucks. We do the same thing. We've been doing it for 28 years. In 2022, the new company, TTS, said, hey, we've been doing business for 20 years. So if TTS only was formed in 2011, that would only go back 11 years. So if they're saying they did business for 20 years, 9 of those years must have been when they were doing business as TTR, the old company. So the judge took all those into consideration and said, hey, yeah, this company is the same thing as the old company. You see what I'm saying? I mean, they have the same employees, they're advertising the same, everything else. Those are all material differences in the causes of action that were asserted here. And again, what happened here is there are several types of bankruptcy, and usually when you think about a bankruptcy, you think about you're getting a discharge. In a corporate Chapter 7 bankruptcy, there is no discharge. And if you look at the cases, there's plenty of cases in this that are doing the same thing. I mean, this is not a novel type case that we're doing. The law is set out in the National Labor Relations Board, the Better Building Supply Corp. It says that partnerships and corporations may not discharge their debts in a liquidation proceeding under Chapter 7. In adopting Section 727A, Congress intended that corporate debt would survive Chapter 7 proceedings and be charged against the corporation when it resumed operations. So it's the same thing we're doing here. What they were trying to do is, there is a provision under Chapter 11 where you can get a discharge, but it's expensive to do that, and it's cumbersome to do that for a corporation. So what they did is they did a cheap Chapter 7 case, hoping that this would all go away, but it didn't. So, and if you look at particularly Seminole Boatyard is very interesting too, because that's a Florida case. In this case, Seminole Boatyard leased property to another company, FAM. There's a guy named Christoph who was the president of FAM. There was litigation. Seminole recovered a judgment for rent against FAM. FAM then filed a Chapter 7 bankruptcy, just like we have today. Christoph goes to the Chapter 7 trustee and he says, hey, I'll tell you what, I'll pay you 50 grand, or I think it was 55,000, for a full release of all claims that the company may have against me, okay? And so the trustee said, okay, we're releasing you, Christoph, from any claims at all, any potential claims that the trustee has. The creditor, Seminole Boatyard, keeps going, it pursues an alter ego claim against Christoph. The trial court says, no, you can't do that. There was a release. You didn't object to all that stuff. You could have gone and paid more for that and gotten the release yourself, but you didn't. So you're done. You're out. The fourth DCA reverses. It says, wait a second. Seminole Boatyard is pursuing an alter ego claim. The trustee could never pursue that. It didn't have standing to pursue it. And it's kind of a weird legal concept that in order to have an alter ego mere continuation case, it has to be brought by a creditor. The company can't do that. If there was a fraudulent transfer case, the company could do that. That is, if you had Coca-Cola and their directors spun off something illegally, the shareholders of Coca-Cola could say, I want that back, okay? That's a fraudulent transfer. That can't happen with an alter ego claim. And then if you look at there's other cases such as Izzo Golf. We went through that. Izzo Golf is very interesting as well. It's the same thing. There was a big trademark infringement case. There was a judgment for $12 million. The company filed Chapter 7 bankruptcy. There was also an alter ego claim going on at that time. The King Park trustee filed a fraudulent transfer adversary proceeding, which is like a separate adversary, like a separate lawsuit. And it said, well, we're seeking those assets back. If you look at the case, it's very interesting. The trustee also filed an alter ego claim, but then the trustee realized, and the court realized, in that bankruptcy case, the trustee couldn't pursue an alter ego claim. So they dismissed the alter ego claim. So in that case, there was, similar to this case, there was a notice of compromise. Baird paid money to the bankruptcy case, to the bankruptcy trustee, paid $1.9 million. Izzo filed proof of claim, participated in the bankruptcy case, got some of that $1.9 million to pay part of its claim. Izzo then got relief from the automatic stay, which is what we did, and then they filed an alter ego claim, or continued the alter ego claim against Baird, the shareholder. Okay? The court said, yeah, you get an alter ego claim. There's nothing wrong with that. It cites several cases, and we went through those in our brief. Goodman, NLRB, Jackson versus Corporate Gear, Custom Builders of Steamboat, Inc., that all, you say, yes, you can do this. I mean, so there's a legion of cases that say you can pursue an alter ego case. A couple other cases, the Jackson versus Corporate Gear case that we cited too says that once the bankruptcy is over, there's no reason for the judgment debtor not to go ahead and collect its judgment, and that's what we're doing. I don't think there's no dispute that we do have a judgment. It continues after the bankruptcy. And then Justice Oaks, the Martin case is a little hard to deal. It could be a little hard to understand. Justice Oaks was the big 11th Circuit case. It's cited all the time. And what it says is, if you have a compromise, it can never have preclusive effect. It can never be a final judgment. And that is because you have to have four things to have a claim preclusion. You have to have a court of competent jurisdiction, a final judgment, has to be the same parties, and it has to be the same claims, causes of action. And so Justice Oaks says, what is going on when the court approves a bankruptcy settlement is that the court just says, hey, is this in the best interest of the estate? And it considers the chances of success, the expenses that the trustee is going to have to incur to go after somebody, the length of time, things like that. So that's all it's determining. So again, that is not the same claim we're talking about as to whether an alter ego exists. That is, whether the company is the same company, whether it ran its own race, okay? And if you look at, there's the case that we cited, HDR Architecture, is also a bankruptcy case. HDR Architecture says, just because there's a settlement between two different parties, the trustee and another party, because there's a third party that is a part of the bankruptcy and doesn't object to that settlement, that doesn't make them part of the settlement. So that is, GT is not a party to that settlement with the trustee right under HDR Architecture. That's the case that says that. You already asked, I think maybe Judge Cobain asked that. There is a narrow exception in Martin v. Pathos, which is a case where the debtor was getting sued. There was a judgment against the debtor. The debtor then came in and said, I want to undo the judgment because I wasn't properly served. He filed bankruptcy, okay? The trustee comes in and says, I want to settle this thing. Mr. Creditor, look, you give me some money and we'll agree this case is over. There's a possibility of upsetting your judgment, but you give us this money, we'll settle the case. They go to the judge, the bankruptcy judge. The judge says, yes, I approve settling this particular case for this much money. That case is over. The bankruptcy trustee can take the money. After the bankruptcy, the debtor comes back and says, well, wait a second, I want to relitigate that case because I was never served. So I want to get back all this money from the creditor. And the judge says, wait a second, you can't do that. That is the same parties, the same issues. The same issues where he's trying to relitigate the defense of improper service of process. And that's the same thing that the trustee gave up, okay? And so it's the same parties, it's the debtor. The trustee stepped in the shoes of the debtor. So in that case, it's a narrow exception to the Justice Oaks rule about this never claim preclusion. Let's talk about our fee. We would also ask, we're asking for affirmance of the judgment. And I will like to, if you look at the judgment, I think Judge Dees did a really good job. It's a 28-page judgment. He spent about, I think he spent about 6 or 7 months debating this thing because there's a lot of crazy things going on. But he did find that we're entitled to attorney's fees and costs under 5629. There was a supplemental judgment for fees that was issued. And in that case, the judge finds that we're entitled to fees under both 5629 and the lease between GT and the appellant, which was assigned to my client, and that master lease agreement provides for prevailing party attorney's fees as well as fees on appeal. So we're asking for affirmance of the fee judgment as well as we're asking for fees on appeal. There's a couple things in the appellant's reply brief. There are 2 cases that he talked about under prayer. He's saying, well, prayer says that you can only get a continuation judgment if it's an employment litigation case. What Prayer actually says, it says, well, there's a general rule of non-successful liability if a company, takes over the assets of another company. It says one exception is if there's an employee that has a claim against the prior company. Prayer doesn't say that only, labor relations or employee cases involving Chapter 7 businesses can result in a judgment after the bankruptcy. And certainly Izzo and Seminole Boatyard and the other cases that we cited are involving cases other than employment litigation. Also, the reply brief talks about Molinos, which is another 11th Circuit case distinguishing Seminole Boatyard, but that case, it doesn't involve a bankruptcy, it's not on point. It just says that you have to, in order to pursue an alter ego claim, you have to go after a shareholder of the company. Okay, so it doesn't talk about a bankruptcy or anything like that. And I think that the key thing that if you look at the appellant's brief, they're trying to say, well, the trustee, he said on page 9 of the reply brief, the trustee had full authority to bring an alter ego claim. There's no way that could happen. If you look at Seminole Boatyard says 180-degree opposite. It says the trustee could never bring an alter ego claim. So I just think for all those reasons, the court should affirm. Is there any questions I can answer?
Thank you.
Thank you.
Where to start? I disagree with all of the legal points that Mr. Kohler has made, which will not surprise you. Let's deal with the Seminole Boatyard case first because he places great reliance on that. 10 and 11 in the reply brief discusses it in detail. That turned on whether a debtor corporation could attempt to pierce its own corporate veil and sue its controlling shareholder. That has nothing to do with this case, which is the trustee's sale approved by the bankruptcy court of the sale of the debtor's assets to my client. In the Lama case out of the 11th Circuit,
I think what he was arguing with that case is saying that the alter ego could only be, or the alter ego claim could only be brought in state court, not in bankruptcy court. Does that case say that?
it does not. And what the 11th Circuit in Lama, doing a survey of Florida law, this is on 10 and 11 of the reply brief, that if Florida law, and I'm quoting, if Florida law allowed such a claim, it was part of the debtor's bankruptcy estate. And because the Fourth Circuit did not specify whether the target of this piercing was even a shareholder, the 11th Circuit said even if this individual did not own stock, which you couldn't tell from the Boatyard opinion, this would cause the Florida Supreme Court to pay this precedent little heed. So that's an outlier case, factually distinguishable and legally not relevant to this case. The question that keeps coming, or the argument is an alter ego is not the same as a fraudulent transfer. No, but they both come out of the same operative facts, and that's what the claim preclusion and res judicata analysis points out. I urge this court, and I know you will have looked at this and will again, the Justice Oaks case and the Martin case, when read together, are clear that all that Justice Oaks dealt with it saying that a settlement agreement is not enforceable is because it was an interim agreement in a Chapter 11 where you had a comprehensive plan which acted as the truly final judgment in the bankruptcy. And that subsumed the interim order, that the settlement agreement that the Wallaces in that case tried to appeal. The Martin case makes clear that it's indisputable that the causes of action involved in Martin are identical since both cases arise from the same nucleus of operative facts and involve the same factual predicates. That's exactly what the alter ego mere continuation claim is. Oh, you've got all the same assets and you're doing the same business. Well, it's not exactly the same. There's plenty of overlap, no question about it, but it was done through the bankruptcy for the reason that that's how you get to keep working on some level and have a trustee who's the fraudulent transfer expert who raised that issue, said this is a fraudulent transfer, you have to do more, and approved it, and the bankruptcy judge signed off on it.
But counsel, and I go back to, you keep referencing the same operative facts. I don't dispute that, but I guess my concern is that doesn't necessarily mean that it's the same cause of action for purposes of res judicata or claim preclusion. Those are both very specific doctrines that are reliant on several factors, and same operative facts does not encompass all those things. Essentially, that just means they need to be brought together, but it could be multiple causes of action arising from those operative facts.
That's why the doctrine says that governs claims that were made or could have been made. And I fundamentally disagree with Mr. Kohler when he said that this mere continuation could not have been brought in the bankruptcy. That's absolutely incorrect. This situation where my client is continuing to do business as a towing company with their name in it, that existed at the time of the bankruptcy. They had years to bring this claim in the bankruptcy court, and they didn't. They didn't do it until they smelled the possibility of doing this new cause of action that they couldn't have raised before. I think it's 7 years after the fact. So, thank you, Your Honors. I rest on my on the brief on the other issues that were raised. Thank you so much.
Thank you. Very well argued case. Thank you.
I thought.
Okay, the next case we have on the docket is Rex Bevins versus the State of Florida, case number 2023-3098. Is counsel for the appellant ready to proceed?
Yes, Your Honor.
Okay.
May I reserve 4 minutes for rebuttal?
4 minutes. Yes, ma'am. Okay, you may proceed.
Good morning, and may it please the court. I'm Michelle Yard, and I represent the appellant. I'd like to discussing the first ground in my brief and why it should be affirmed by this court, because of 2 reasons. 1, I was counsel at the time of my motion to withdraw plea. But 2, even if I was not, there's still a per se reversible error due to the trial court's failure to appoint conflict-free counsel following its actual notice of conflict from the initial attorney before ruling on the motion to withdraw plea.
Counsel, and let me stop you with the ruling on the motion to withdraw plea. So there were multiple motions to withdraw plea filed in this case, right?
Yes.
Okay. So there was a motion filed by, I believe, Mr. Wilson, that may be his name, I can't remember off the top of my head. But right after that, 5 days later, there was a notice of appeal filed. And then you filed the second motion to withdraw. So, and then all of the events that you're talking about transpired. How did the trial court have jurisdiction to address anything beyond that first motion to withdraw?
In this case, the motion to withdraw allowed the trial court to maintain jurisdiction for purposes, or the motion to withdraw plea, to be clear, allowed the trial court to maintain jurisdiction for purposes of ruling on that motion. While it doesn't toll the appellate 30 days, it does allow the trial court to maintain jurisdiction until that is ruled upon.
until that first motion.
Right.
Right.
They were both timely filed. In my case, of course, it took longer because I had to request the audio, wait for the court reporter to provide the audio and whatnot. So mine, of course, was filed on the 30th day. But in this case, as I've explained in the briefs, I was trying to wait for the other attorney to file the notice of appearance because it was my understanding that he could not be withdrawn under 3.111 and 9.140 until he had complied. I had asked him, the client had asked him, and I had asked him to file that notice of appeal much earlier, and he didn't do that. He filed
But counsel, what about, so 9.020, I would agree with that portion of your argument that says that first motion, that motion is acceptable, that tolls rendition, it was timely filed, so that notice of appeal didn't strip the trial court of jurisdiction. Okay. After a notice of appeal is filed, if you then file a motion to withdraw, the court does not have jurisdiction. The cases are legion saying that that motion to withdraw can't be ruled upon unless by the trial court unless there's some other action that's taken. So that's my concern. All of these events transpired after that notice of appeal, other than the first motion that is subject to that 9.020. So that's where I don't think that doesn't mean you have a free-for-all, from what I understand, to file whatever you want to file, and that doesn't affect the court's jurisdiction. So, and I think the Atkinson case from the first DCA especially speaks to this. It talks about pre- and post filed motions to withdraw between when a notice of appeal is filed. So that's my concern, is where was the court's jurisdiction to do all of that?
Your Honor, two things. One is that even if a notice of appeal is filed before a judgment is rendered, it's essentially held in abeyance until the judgment is entered. In this case, I would argue that the motion to withdraw should be the same. But regardless, even if the court does not want to recognize my motion, there's still fatal error here that must be reversed. And that is because the initial attorney who filed the motion to withdraw the plea, it conceded before the court ruled on his motion to withdraw plea that there was an irreconcilable conflict. And that triggered, under the Florida Supreme Court precedent in Shepard, the requirement that before the trial court rule on the merits of that first motion to withdraw plea, that it conduct the inquiry on whether conflict-free counsel was required. Here, even if you never look at my motion, the trial court failed. It did not follow that Supreme Court dictate. It did not conduct that hearing. It did not allow conflict-free counsel. It did not appoint conflict-free counsel. It was notified directly that there was...
He filed his motion to withdraw, though, in response, saying that there was a conflict in response to your motion, correct?
But regardless, he notified...
Is that correct?
Yes, Your Honor.
Okay, and that was after the notice of appeal had been filed. I think that's what Judge Kilbane's getting at. That was after the notice of appeal was filed, correct?
The motion to withdraw as counsel?
Yeah, that came
Yes.
after, correct.
Your motion to withdraw a plea, let's call it the second motion to withdraw a plea, and I want to be careful because you have a motion to withdraw a plea, you have counsel's motion to withdraw as counsel, so I want to be somewhat careful, and I think I want to build upon the question of my two colleagues. The purported conflict of original trial counsel was born because of the contents of your motion filed on behalf of the appellant, right? That's exactly what Judge Boatwright just asked.
That forced the attorney to concede that there was a conflict because of the allegations of the client against him.
Understood. And your motion, though timely, even if timely under the rules of procedure, was filed after the notice of appeal, was it not?
It was, Your Honor.
So would not 5th DCA precedent also dictate that the motion to withdraw a plea filed after the notice of appeal and any court's consideration of that subsequently filed motion to withdraw a plea would be a nullity because the notice of appeal had divested the trial court of jurisdiction? You agree with that?
I don't agree with that, but I don't think it's fatal to the argument here, because the motion to withdraw plea was filed before the notice of appeal. And then...
The original motion to withdraw plea.
Yes, so not even talking about mine, right? There's the motion to withdraw plea, then approximately 5 days later, there's the notice of appeal, all from the original attorney. And then, I believe 2 days later, the attorney moves to withdraw due to conflict. So for whatever reason, whether it was my motion or he spoke with the client, we don't know the reason, right? He says that he can no longer represent Mr. Bevins and that there is conflict and that he can have no involvement with Mr. Bevins, the appellant, whatsoever, is what he says. So the court then waited some almost 6 weeks to rule on that initial motion to withdraw. And it knew from 5 or 6 weeks prior to that that there was a Shepard issue, that the attorney who filed that motion to withdraw, on which the court was going to rule, had said, I can't be involved in this case. And that triggered the required hearing under Shepard. For whatever reason, if the attorney told the judge off the record that he had a conflict, it doesn't matter. Once the judge is on notice that there is irreconcilable conflict, an adversarial relationship between the attorney who filed the motion and has not, before he has ruled on the motion, that triggers, under the Sixth Amendment, a right to conflict-free counsel. And that didn't happen here. I mean, Mr. Bevins, the intention was clear, even ignoring my motion, that he intended to move to withdraw his plea.
But counsel, how do we ignore your motion if we're looking at Shepard, if we're saying that's where the defendant's motion to withdraw pursuant to 3.170 suggests a conflict between the defendant and counsel? That suggestion arose from a motion to withdraw a plea that was filed after the notice of appeal.
I mean, that's a presumption that the court's making. I mean, for all the court knows, the original attorney spoke with Mr. Bevin.
Well, that's what but isn't that what the motion to withdraw as counsel from Mr. Wilson, isn't that what, I can't make assumptions, I have a record. And most of that record has a jurisdiction issue, but if I'm looking at those things, you know, all of that arose, it was alleged in the motion to withdraw a plea, okay, then the response, because that was filed by a different attorney, so not the one he's alleging to have the conflict with. So that's sort of the issue. Is there a Shepard issue that we can look at here?
There is. I mean, the facts of this case are no different than Shepard, right? Where in Shepard there was a pro se motion, right? And the issue there was the individual was claiming that there was a conflict and the judge didn't do anything, right? The motion to withdraw plea is a critical stage of the criminal proceeding. The person is entitled to effective conflict-free counsel under the Sixth Amendment. To find that the court, after having been notified by the attorney who filed the motion that there was an irreconcilable conflict, cannot somehow act on that would result in a violation of the Sixth Amendment. It results in Mr. Bevins not having a meaningful opportunity to be heard. It results in a violation of due process. The judge, Shepard, at a minimum, triggered the inquiry. At a minimum, Shepard says that if there is a suggestion of an adversarial relationship, the court must hold a limited hearing to determine whether that adversarial relationship requires the appointment of conflict-free counsel.
I don't know that anybody disputes Shepard. And let's say for purpose of the argument that your point's well taken in that regard. We still have to deal with the notice of appeal. That notice of appeal has jurisdictional consequence for the trial court. That's what I think we're trying to wrestle with, and we're trying to allow counsel an opportunity. And I still don't know precisely how a motion filed after the notice of appeal can be considered by the trial court on the merits. And the subsequent question, or the related question, would be if there is a conflict asserted by that subsequently filed motion to withdraw a plea, what is the impact of the notice of appeal on the jurisdiction of the trial court to consider the matter raised in the subsequent motion to withdraw a plea? That's where it's not what does Shepard require. It is not, should the trial court have held a hearing if both motions were filed prior to the notice of appeal? And I understand you had to wait on the record and all those sorts of things. Nobody's questioning your timing or sequence. But ultimately, if both motions were filed prior to the motion to withdraw a plea, then would Rule 9.020 consider the matter premature and allow the trial court to rule? I think that's one dynamic. But at least I'll speak for myself, what I'm trying to come to grips with is the effect of that notice of appeal on the trial court's jurisdiction as it pertains not only to the first motion to withdraw a plea, but the second motion to withdraw a plea and any relationship between the two motions to withdraw a plea.
I believe that once the motion to withdraw a plea was filed before the notice of appeal, that allowed the court to maintain jurisdiction exclusively for the purpose of the motion to withdraw the plea. The court in Thomas v. State, cited in the appellee's brief, found that right after the 30 days have expired, that there was no jurisdiction to file a new motion. In that case, the attorney filed after the 30 days, under which 3.170L allows the motion to withdraw a plea. The attorney filed a motion to reconsider the ruling. And what the appellate court found was that the judge could only rule on the original motion, that the motion to reconsider, which was filed outside of the 30 days, was no longer jurisdictional. So I would maintain that for purposes of jurisdiction, the motion to withdraw plea, having been filed before the notice of appeal, allows the court jurisdiction to maintain the issues in ruling on that motion. I just don't agree that the notice of appeal divests the jurisdiction of the court for a motion that was timely filed before the notice of appeal.
So so would the first motion operate as a placeholder almost?
Yes, I mean, in the rule, it says that 3.170L, that you have to file the motion within 30 days. It does not say before a notice of appeal. It doesn't say that in the rule. And I feel like if that was the operative fact, that the rule would include that. So I think presuming that the notice of appeal here divests the court of jurisdiction for the timely filed 3.170L motion is incorrect.
And I want to make sure, and I don't want to dance on the head of a pin unnecessarily, the motion to withdraw a plea that you filed on your client's behalf, that was not an amended motion, correct? You did not, that was not filed as an amended motion. You filed that as a motion.
Yes.
Okay.
Yes, the client retained me to file the motion to withdraw a plea because of the conflict with Wilson. So I was filing the motion that I was retained to file. I was not intending to come on as substitute counsel. I was coming on as additional counsel, which is why I filed the limited notice of appearance.
And I'm not taking issue with what you did. I'm just trying to make sure that I'm accurately recalling the nature of the filing.
In Hicks, which was a 50CA case, the court held, quote, that there is good reason to proclaim that a lawyer's premature actions taken in the best interest of the litigant have no legal effect. No good reason to proclaim that. Hicks also found that the restrictions on the rights to the access of the court should be construed to favor the constitutional right. And then in Shepard, the Supreme Court stated the general rule of striking pro se pleadings is designed to improve the administration of justice and not to frustrate it. I contend here that Mr. Bevins, the appellant, was denied any genuine opportunity to have his motion to withdraw, and talking about the initial one, considered fairly. He did not receive due process on that. The court cannot turn a blind eye. For whatever reason, if the court finds out there's a conflict, the court cannot turn a blind eye and ignore the Sixth Amendment and the dictates of effective conflict-free counsel. And there was a failure here, and that failure requires that there be a reversal at a minimum to hold that inquiry as to whether conflict-free counsel is required. In all of the cases cited in the briefs where conflict-free counsel was not appointed before a judge ruled on the merits of the motion, they were reversed and they were remanded for that inquiry to be completed. And that has to happen here.
Ma'am, you're into your rebuttal time.
Thank you, Judge.
Excuse me. Good morning. My name is Robert Bradford, and I represent the state of Florida in this matter. With respect to the first issue, I'd like to begin by talking about the two cases that appellant seems to rely on the most, Shepard and Hicks. Shepard was...
Let me ask you about that. Let's go ahead and start. Let me ask you didn't raise it in your answer brief. What about this jurisdictional issue? Did the trial court have jurisdiction to hear any of these motions after the notice of appeal was filed?
Your Honor, it did not. And the reason I say that is because the 5th DCA, this court has issued cases in the past which hold that untimely motions filed after a notice of appeal are not effective. There was the 4th DCA case, I think it was Adams, that held that if it was a timely motion that was post-judgment.
So you'd agree the first motion was timely?
First motion was timely, yes, sir.
What about to her argument that once counsel stated that he had a conflict, that the judge had a requirement in dealing, he had not dealt with the first motion yet, that he should have held a Shepard inquiry at that point?
Well, and this is what I was getting ready to say about Shepard. The problem with that is that Shepard dealt with a case where a represented defendant filed a pro se motion. This was not a case where a second attorney tried to make an appearance. And as I argued in the brief under the general rules of general practice and judicial administration, there are specific ways that an attorney can appear on behalf of a client in the state of Florida.
But does that really matter once counsel says, hey, I have a conflict? I mean, does that really matter at that point who filed the motion, whether it was pro se or an attorney filed a motion that started that process?
It does in the sense that Shepard, the holding in Shepard, the specific holding was that the represented defendant in his pro se motion did not need to make an unequivocal request to discharge the attorney. That was the specific holding. It reversed a line of cases that went back to, I believe it was the Logan case in the early 2000s, where the Supreme Court said, no, and because Florida jurisprudence for as long as I've been licensed has been that a represented defendant in a criminal action, if they file a pro se motion, it's a nullity. And so therefore Logan said, well, so the defendant has to make an unequivocal request to discharge the attorney. But then Shepard kind of stepped back from that and said, well, no, this motion, it's pretty clear that that's what was created, was an adversarial relationship. If you didn't use the magic words, I request to discharge my attorney, that's okay. That's all the holding of Shepard says.
Why does it matter whether he does that or another attorney does that on his behalf, though? That's what I'm asking. Why does that matter?
Again, because since going back, I think the case I cited in my brief was from 1939. Even before any rules, it's been the law in Florida that for another attorney to appear on behalf of a litigant, that they had to be substituted in if the person already had an attorney. There's only one way to make an appearance in the state of Florida. There's only one rule that governs appearances in the state of Florida, and there's the same rule governs.
Limited notice of appearance was not sufficient?
The notice of limited appearance in this case said that it was for limited purposes of post-conviction relief. Now, I understand this was after conviction, and I understand this was some sort of remedy, and so it was constituted relief. But in the criminal law parlance, post-conviction relief has a specific connotation. And it has a whole rule devoted to it, 3.850. And in fact, ultimately, that's what this case needs to go to. It needs to go to a 3850 hearing, a proper motion, and a proper hearing so that issues such as strategic considerations, whether there was evidentiary support, whether there was support in the law, whether Attorney Wilson had specific strategic, reasonable strategic intentions for how he presented this case at sentencing.
But once he notified the court, let's take out the jurisdictional issue. Once he notified the court that he had a conflict, you're saying the court doesn't have a requirement at that point to hold a Shepard hearing when the attorney says I have a conflict?
Well,
I mean, the attorney in this case, correct?
The court doesn't have a hearing in the sense that, well, in addition to the jurisdiction, this attorney, there was no proper appearance, there was no proper termination of the other appearance. So I think the court stated in a later motion, maybe the motion that denied the reconsideration motion, or the order denying the reconsideration motion.
When counsel's motion to withdraw, he says, I have a conflict, right? Correct.
Created by the second motion to withdraw the plea, yes, which was unsworn, unverified, and unsupported by an affidavit. So they're allegations, but again, we have no evidence. In a 3850, it has to be either, sworn motion, it has to be that statement under penalties of losing my privileges in the Department of Corrections, et cetera, et cetera. None of that's here. We don't have that. The court specifically felt from the time that Attorney Wilson was allowed to withdraw until Attorney Yard filed her second notice of appearance and the second notice of appeal or amended notice of appeal. Ms. Revens, the appellant didn't have any attorney, not an effective one, not that required the court to do anything, because the specific holding in Shepard did not say that conflict-free attorneys don't have to follow the rules. Now, and I think that the holding in Hicks also is relevant in the sense that in Hicks, which was a civil case, obviously, Hicks versus Hicks, the time frame was not 30 days. The time frame was 10 days. It was a motion for rehearing, trying to get the order of substitution, and that was at page 304 of the opinion. And they cite to the specific rule. I think it later went to 15 days. But in any way, in 10 days, it's very difficult for somebody in prison to hire a lawyer, bring them up to speed, get everything accomplished. The Hicks court recognized that. But in addition, in Hicks, there was evidence that they attempted to comply with the rules. And as I recall, I believe they even supplemented the record later on with the proper paperwork after the fact. And the Hicks court, I think the most important aspect of that decision to say why it doesn't apply in this case, is that it distinguished the Bortz case, which was from the first DCA, because in Bortz, there had been no effort to comply with the rules for substitution. They say that on page 305. Without any effort, this case, it should be controlled by Bortz and Thomas and Quail Hollow Properties. And even so, as was noted before, the sentencing court didn't rule on the motion to withdraw. Didn't rule on the first motion until November, I think, like 6 weeks later, I believe it was, something along those lines.
So the court at that time had noticed that the attorney was claiming he had a conflict before he ruled on the motion, correct?
Yes. Okay. There was some kind of claim to a conflict, but not in any effective...
So you're saying not in every situation that doesn't trigger an automatic...
No. Well, first of all, it's the same sense that the motion to withdraw a plea has to be filed before the notice of appeal. I mean, even if there's good reason to withdraw the plea, if it's after...
What do you make of original trial counsel standing before the judge and saying, I have a conflict? not the second motion, things of that sort, set that to the side just a moment. If I hear Judge Boatwright correctly, the original trial counsel himself said there's a conflict. Well, what is the trial judge to do with that? Just, well, the notice of limited appearance wasn't phrased correctly or something of that sort. I still don't, we're setting, for purpose of the argument, apparently we're setting to the side the notice of appeal just a minute. But is the trial judge permitted just to move forward when trial counsel says, I have a conflict? We just keep going?
After the plea has been entered, after
Sentencing, after plea, 3170L is triggered? Yeah.
Yeah.
Just ignore it and move.
You move it and go on. Like I said, it's a proper issue for a 3850. And that's where this case should be resolved, in a 3850 motion.
And just so it's clear, there was no hearing held, correct, on the motion to withdraw plea? The only order, I think, that really encompasses the motion to withdraws with an S, because I think he referenced the other one. There was not a hearing on that, is that correct?
That's my recollection. There was no hearing.
There's no requirement for him to have a hearing, correct, on that?
No.
I just want to be sure, because we're referencing that trial counsel was standing before the judge essentially saying, I have a conflict, but it was filed in the court file, you know, it's out there, but he didn't address it before, you know, was he aware that it had been filed? I don't know that. I didn't see that in the record. And do you think that matters?
No, I don't. No, I don't.
Okay, and you've referenced 3850 several times, and I understand the argument. Are you suggesting that we would be able to address that as the appeal stands now?
No, absolutely not. For ineffective assistance to be considered on a plenary appeal, it has to appear on the face of the record. It has to be just very, very significant.
Do you think after Dortch we could still address that in this fashion, in that fashion that you just referenced?
Gosh, I just read Dortch for my last appeal that I briefed, but you'll have to remind me.
Essentially saying that there is no fundamental error review, that you can't do a 3850 apparent on the face.
That's correct, yes. I'm not sure that's viable anymore. With respect to the merits of the departure issues, as far as the sentencing errors, and of course, Attorney Wilson's motion, the first motion, was found to be insufficient, legally insufficient, and I think that was a proper decision, because after sentencing, it's limited to the 9.140 issues, and the only issue that would be applicable to his motion would probably be a sentencing error. But it has to be a sentencing error if preserved. Now, his motion talks about the court being bound by the score sheet. The court did consider itself bound by the score sheet in the sense that that's what the scoring, the punishment system is, and the sentencing provision is supposed to be. But I'm sorry, I lost my train of thought.
That's okay. And if it was a sentencing error, that could have also been brought pursuant to a 3800B, even after the notice of appeal, but prior to the initial brief, correct?
Correct. And what I was getting ready to say is the 9.140, it's a sentencing error if it's preserved, and it wasn't preserved. And so therefore, I mean, when the court basically announced that it didn't see any reason for a departure, and I don't know if I made it specifically clear in my brief, but the court didn't, I don't think, misunderstood the could and should aspect under Banks. It basically said there was no evidence that supported, there was no competent substantial evidence that supported any of the grounds that were presented. which at best would have been specialized need, and of course the amenability argument, not that I'm willing to do it. That's not what amenability is in the departure sense. It is whether the treatment, specialized treatment, would be successful. And according to the psychosexual evaluation and report that the judge read and reread, he said they'd had a moderate risk of reoffending and that he was a pedophile. It didn't say anything about being able to cure him. It said he could manage his moderate risk of reoffending by depriving him of internet access, but that doesn't necessarily deprive him 100% anyway. With respect to the open plea, there's binding case law already that says an open plea is not a plea bargain for purposes of departure, so the court could not have erred in that regard. It was following binding precedent. With respect to the cooperation and remorse obviously
about the involuntary civil commitment issue that was raised.
Yes, sir.
And looking at the rule, it says the trial judge must, and it goes through there in subsection 9. I think most of us, we're trial court judges, so we're familiar with reading this during the plea colloquy. That was not done, correct?
That was not done.
Okay, and then I think the last part of that rule says, as this admonition shall be given to all defendants in all cases. Had her motion been proper, not for the jurisdiction issues, what is your response to that?
They still haven't made any showing of prejudice. 3.172.
So is that the last subsection that you're looking at in that rule that deals with prejudice? Is that what you're relying on?
3.172, yes, sir.
Okay. And what about the Partlow case? You cite to that dealing with the prejudice issue.
Well, yes, sir.
And I think that had to do with sex offender registration, which is not part of this rule, correct? So there's a factual distinction in that case. Is that right?
There is a slight distinction, but the court, I believe the Partlow, or the Klein case, held also that civil commitment under Jimmy Rice is not a punishment. So therefore, it need not be expressed in that regard. Certainly, the rule does require it, but and that's why I cited the Warnos case. Obviously, in that case, the failure to notify of minimum and maximum punishments, the possibility of deportation, perjury charges upon false sworn statements, and trial rights that were being waived. I mean, I've never, honestly, in my days practicing criminal law, I've not seen or even heard of a plea that
is this offense, that these offenses that he pled to, are these offenses that would potentially subject him to involuntary civil commitment under Jimmy Rice?
possibly. And with respect to the remorse and cooperation issues, again, I don't think those were preserved issues, but if they were, then remorse shouldn't serve as an issue for departure, especially when it wasn't raised, in light of the sense that the two other elements that are part of that, the isolated incident in an unsophisticated manner, there was no evidence supporting that. He apparently had been looking at these, I think, these pictures for over 10 years. And he was originally caught because he had uploaded a file onto the internet, which triggered a notification to the national hotline, which came back down again. So I don't know that that qualifies as unsophisticated or could qualify as unsophisticated. And with respect to cooperation, State versus Platt is binding precedent. Cooperating and confessing after you get caught is not a reason for the departure. I understand opposing counsel has argued that because the list in the rule isn't the exclusive list, that the court can consider other reasons. I would submit that that does not include the situations where you're only able to get to part of or one or two of the elements, but not all of the elements in a listed departure reason. I don't think that filters down and you can say, well, because I can only get remorse and I can't get the other two, that's good enough. I don't think that's proper. As far as the general sentence, these were 20 identical counts. The judge just didn't want to repeat 20 times the sentence, and he just ordered it one time. He made it concurrent. That's not a general sentence. A general sentence is one that covers third-degree felonies, second-degree felonies, misdemeanors.
What about the appellant's argument in regards to, I think there's an issue, there's a scrivener's error between a second-degree and a third-degree felony mentioned on the judgment. There was a mistake as to the designation. Is that something we can review if there was actually a scrivener's error based on what we've discussed here today?
Yeah, I think if there's a scrivener's error and it says something other than second-degree felony, then it probably should be corrected to make sure that's proper, because it was second-degree felonies, 20 counts of second-degree felonies. So unless the court has any other questions, I would rely on the rest of the arguments in my brief and ask you to affirm in all respects.
Okay, thank you. Ma'am, let me ask you before you get started, in regards to if your second motion is a nullity, you said, but hey, you still need to discuss the Shepard issue. So let's say you're right on that. Okay, so let's say he now gets a new counsel. You're still stuck with that first motion, though, correct? I mean, there isn't going to be the issues that you've actually raised are much different than the first motion, which you've raised here on appeal. Those are done at that point, even if we were to agree with you, correct?
I disagree, Your Honor. The case law is replete with all of these pro se motions, what were ruled upon without conflict-free counsel. When they are remanded, they are always remanded for the defendant to have the ability of conflict-free counsel, including the ability to amend the motion. One of the cases cited in the brief, I would have to review my notes, had that exact situation. The case was remanded. The judge did not allow the conflict-free attorney the opportunity to amend, and that was again reversed. In this case, as far as the jurisdictional issue, 3.111 and 9.140 require that an attorney not be allowed off the case, the sentencing attorney not be allowed off the case until they file a notice of appeal. In that situation, a client could never hire a new attorney to do the motion to withdraw the plea, because the new attorney cannot come on until the first attorney withdraws, and the first attorney cannot withdraw until the notice of appeal is filed. It's a conflict in the rules, it is unworkable, it is unfair, and it deprives people of their Sixth Amendment right. As far as the idea that this should be resolved in a 3850, Shepard spoke on that. Shepard said, and I quote, "Deferring issues to the post-conviction process that can be effectively dealt with at an earlier point is neither efficient nor preferable." If I can move on to the Jimmy Rice issue for a second, the state cites Klein for the idea that this warning was merely collateral and therefore not prejudicial, but that's contrary to the precedent. Here in Partlow, the Florida Supreme Court held, and this is, quote, "The voluntariness of a plea depends on whether the defendant is aware of the direct consequences of the plea and those consequences listed in Florida Rule of Criminal Procedure 3.172C. At the time that the court considered Klein, this warning hadn't yet been added into 3.172C. So I would argue that the case law discussing whether the warning was essential before the rule was amended is superseded by the rule amendment. As far as the downward departure, here the attorney made an argument for downward departure for mental health treatment based upon a specialized need. He submitted and was received into evidence a psychosexual evaluation that indicated that treatment would be effective in this case, that treatment was available, effective, that the defendant was willing to participate in that treatment. That psychosexual evaluation, in conjunction with the attorney's arguments, provided the step one basis under Banks for the court to downward depart. The court failed to acknowledge that, it failed to make findings on that. May I finish my sentence?
You may.
And that is error under Banks.
Go ahead.
You'd like to have one more minute. We'll give you another minute to finish.
Yeah, go ahead.
We'll let you finish your argument on that point. We took up some of your time on issues you weren't probably prepared for.
So here, there was a psychosexual evaluation admitted into evidence without objection, and that psychosexual indicated that there were positive indicators towards rehabilitation, there was a willingness to, and I'm quoting, a willingness to accept responsibility, there was a recognition that he needed treatment, there was a willingness to comply with treatment, that treatment could result in his DSM-5 conditions being managed successfully, that they could be managed with treatment, and that he had positive indicators towards rehabilitation. That allows the court the basis necessary to find that it can downward depart for a mental health condition requiring specialized treatment and a defendant that is amenable to that treatment. The court finding here that because there wasn't a negotiated plea with the state, the court only ever addressed that. And he says, nope, there's not that, so there's no basis to depart here. And that was an error. And in the Green case, the court remanded for the exact same error. The court stated in Green that the trial court erred by making no specific findings as to the availability for departure under, in that case, subsection DRI, which mandated reversal, and Green was reversed.
And counsel, if I could just, I know we're over time, I just want to address the issue you brought up with respect to a conflict. You say there's a conflict in the rules. Has this court or any other court ever addressed that or elucidated that? And you did not file that below, is that correct? You didn't indicate that as a problem below?
I indicated in my briefs that there was a conflict with 3.111 because in order for me, the only reason I filed the limited notice instead of just filing a notice and seeking substitution was because 3.111, and the rule is repeated in 9.140, the same rule, that an attorney, the sentencing attorney, cannot be withdrawn until the notice of appeal is filed. And I didn't indicate that in my briefs, that is why I had to file the limited notice instead of seeking substitution.
Okay, thank you.
Thank you.
Have any other questions?
I do not.
Okay, all right,
Thank
thank
you,
you,
Your
ma'am.
Honors.
Thank you.
Thank you, both of you. Very well argued. Thank you.
Yes, thank you.
We will stand in recess.
All rise.